Hello, welcome to this lecture on the Supreme Court today. So, just to begin, I'm your instructor, Daniel Kirsch. So, it's kind of a longer lecture here. I try to abbreviate it where I can, but welcome to this discussion of the Supreme Court and to a certain extent the federal judiciary, which I hope today is not to talk too much about any individual cases. That we'll discuss more in the Civil Rights and Civil Liberties chapters and other chapters. I want to give you an introduction to the way the Supreme Court works and maybe why it has some of the power it does. There are a couple of resources I'm also going to post on the course website. So I will be able to get a look at some of those and kind of what this material means, so you'll be able to do that. Let's see. So we'll take a broad look at the U.S. Supreme Court and the federal court system. Then we'll take questions individually as they come up. So to start off, why talk at all about the Supreme Court? There's this power of judicial review that they have. And it's the reason, really, we care about them. It's a power that was first articulated in a document called the Federalist Papers by an author named Alexander Hamilton, who I've mentioned in other lectures, back in 1788. I'm paraphrasing a little, but he essentially said that the Supreme Court will have neither force nor will, merely judgment. They would have neither the purse nor the sword. He might have been underselling it a little, but these were references to the Congress and the presidency, Congress having the purse, power to spend, tax, but force and the sword, the purse and will. Congress is supposed to sort of set the direction of the ship of state. But the force and the sword belong to the executive and to the military. He said, look, they're not going to hurt anyone. They're a legal body. We need one. They're there so you can have clarity about how the law is supposed to work. We're setting up several branches of government, and so in a constitution, you need a court, which has the power of something called judicial review. It's this ability to decide not only what the law is, but it's what the Constitution says and what it means. He explained, look, if you have a system of laws and you set up a government one day and then the legislature, maybe even with the help of the executives, decides to write a law that totally contradicts the basic constitution that we've all agreed to, you might as well tear it up. Because if you can amend it simply by writing a law, then we might as well revert to the British system where that's exactly what they do. So the British have no one basic document. No one single document that's called a constitution. They just call their system of government a constitution. They just have a body of laws that can be changed by majority vote. So at any point, we need a system of laws that has a hierarchy. We need a constitution that supersedes those laws. We need a body that tells us that what the Constitution means in any context, and when those laws are violating the higher law of the Constitution. So we said a Supreme Court is necessary, at least initially. So it wasn't a prestigious position. One justice left the Chief Justice position to get the Chief Justice position in South Carolina, which I believe paid better. So that may be something. So everyone knows today that there are 9 justices, right? But back when there were 6, it's fluctuated to a point where it did have 10 right after the Civil War, maybe during the Civil War, but since then it's been about 9. But it's not going to change anytime soon, it doesn't look like, although Congress can just pass a law. So it's not a constitutional requirement. They can increase it to, say, 15 if they want. It is a constitutional requirement so that there is one, the Chief Justice, and any others that Congress deems appropriate. So, Chief Justice John Marshall, I should start with him. He assumed the Chief Justiceship that really gave definition and power to the office in 1801. So it was some time after Constitution was adopted by the states that the Chief Justice really had any power to speak of. But it's because of this very political battle that went on between John Marshall, who was a member of the Federalist Party, and Thomas Jefferson, who was a member, the leader really, of his own political party, Jeffersonian Republican Party. So the Federalists wished to, and this is Alexander Hamilton's party, by the way, John Marshall's party. But John Marshall was Thomas Jefferson's cousin too, so there was that bit of drama apparently going on. But the Federalists did want to expand and strengthen the federal government in order to stabilize the young economy and the young republic. So the Supreme Court itself became this body that did basically all of that eventually. John Marshall led it from 1801 to 1835, and no one has sat in the Supreme Court for as long as he did, let alone the Chief Justiceship. The Chief Justice himself or herself has a lot of influence over opinions. So Marshall establishes this power through a couple of interesting political maneuvers. The power of judicial review and the power to declare laws from either the state legislatures or Congress null and void is called judicial review if they contradict the Constitution. He was able to assert this through a case called Marbury versus Madison. And without going into the facts of the case really at all, I can tell you this, and you can watch one of the videos I posted online about it. Essentially, he would have rewarded the members of his party with jobs if he heard their lawsuit and ruled in their favor and awarded them what they wanted. But because he knew the Federalists were out of power now, even though he had this life appointment as a Supreme Court justice, in the executive and legislative branches now, Jefferson's allies outnumbered the Federalists by a wide margin. He knew that Jefferson was not inclined to obey the wishes of the Supreme Court or the pronouncements of the Supreme Court. So Marshall decides to do nothing and assert that doing nothing is proper in this case because the law the Federalists brought to court is actually an unconstitutional law. He coined that phrase. So he declares the law partially null and void, that part of the law that wasn't constitutional. He declared it null and void so they couldn't bring this suit up in the first place. And because of that, he says, I can't award them their jobs or even hear their case. And so his friend Marbury's not happy, but everyone else agrees. And everyone in the political establishment, including Jefferson, agrees that, you shouldn't do this. So they have to agree with the reasoning too, because, they're not lawyers and they, fine. So don't give them their jobs at all. If they disagreed on the reasoning, they just let it go. So Marshall gets to assert this power of the Supreme Court and set this precedent, that's what it means, to set a precedent by establishing a good law, and they let the decision stand, that says the Supreme Court can just declare a law, any law, unconstitutional, part of it or all of it. And without it, really, we wouldn't be able to know the court as we know it today. So paradoxically, he asserted this great power simply because it was easy to do. It was the right thing for the Supreme Court to do, and nothing happened as a result of it. But to get the political assumption at the time to acknowledge that doing nothing was the right thing to do, he ended up in the long run asserting a lot of power for the Supreme Court. So that's what their power is. If a government, the federal or state governments exceed the powers of the government or infringe against the protections of the people or corporations against the government in the Constitution, they can declare that law or policy null and void. We often say that yes, Congress passes the law, President carries out or executes the law, and Supreme Court, the judiciary, interprets the laws. Well, another verb we might use, they declare that laws are binding or they're not employed. So it's not an absolute power. It's not a power to control necessarily the federal government on a day-to-day basis. It's this power that intermittently constitutes a threat to the absolute power of either the president or Congress. So there's a lot of incentive for both of those institutions to shape the Supreme Court and to influence the Supreme Court. They're this lifetime appointed body that has to be appointed by the president. So each seat has to be appointed by the president and confirmed by the Senate. And usually the president gets to appoint at least one or two Supreme Court justices during a 4 or 8 year term. So it's a very political position. Don't let anyone tell you otherwise. It's a powerful political office, just as every other branch of government is. But it's their responsibility, it's their at least political power they've asserted, and everyone else has agreed to have this power of judicial review. They get to decide what the laws mean, and in that meaning, really the power is in the details. Sometimes presidents get to appoint 4 or 5 justices. Franklin Roosevelt got to appoint 9. Obama, he had 12 years. Obama got to appoint 2, but really 3 he appointed, and 2 were confirmed. Merrick Garland, his third appointee, would have been seated on the court, but the Senate never agreed to hold a vote on his confirmation. It was controlled by the opposite party, by the Republicans, and he has now been nominated, and he was nominated by Joe Biden as Attorney General, and he was confirmed last year by the Senate. So he's been this year, by the Senate. The seat he was appointed to he was never seated for, President Trump was able to appoint Neil Gorsuch in that space. And then later, Brett Kavanaugh and Amy Coney Barrett, all 3 extremely, I guess fair to say, extremely conservative choices who had extraordinarily controversial hearings. Less so Gorsuch, but the other 2 certainly. And confirmation votes, particularly Kavanaugh, who was accused of sexual assault as a teenager by a woman who is now a Stanford professor in a televised series of congressional hearings. But let me come back to an idea I made some notes about. There's 2 kinds of jurisdiction the Supreme Court has. One of them is called original jurisdiction, and the other is called appellate jurisdiction. Original jurisdiction cases, according to the Constitution, there are several kinds of cases that can be heard initially in the Supreme Court as the court of first review. It sounds a little strange because it hardly ever happens. So, like someone makes a complaint and the Supreme Court hears it, like no other court has had a chance to look at it first. But it usually involves 2 categories, one either involving public ambassadors from other nations. Usually those cases can also be heard in federal court, but it can be heard in the Supreme Court. Supreme Court can assert that right, but also it almost never does. And another case that's almost never heard anymore is one where states actually sue each other. So that hardly ever happens either. If it did happen, it would make headlines. So one interesting case I'm going to put up on the site for you to read is, if anyone has ties to the East Coast, it's New York versus New Jersey. New Jersey claimed that in the 1990s that Ellis Island was in New Jersey and not in New York. So it's a port of entry. If you're not familiar with Ellis Island, it's where the Statue of Liberty is. It's the port of entry for new immigrants from Europe in the 19th and early 20th centuries. So it's what people see, and they're like, "Oh, it's New York," for all this history up until now. Well, certainly Ellis Island tickets, they say Ellis Island, New York. There's a picture of the Statue of Liberty on them, where on the ship. So culturally, most people recognized Ellis Island was part of, and always had been part of, New York City. But from conversations and documentation, initially when they were dividing up the states, they were using the midway point between several waterways. One of them was the Hudson River between New York and New Jersey. They were saying that halfway between New York and New Jersey is the border of New York and New Jersey, and Ellis Island is right there at the edge, apparently at the New York and New Jersey border. And when Ellis Island was being populated, the Statue of Liberty was built on it, and New York, they needed to use it as support. So there was some fill-in garbage that wasn't there before. They just filled it in, much like the Back Bay in Massachusetts, in Boston. Excuse me. And so it wasn't there before, and there was this discrepancy about the border because what was on land and what wasn't on land. And to use a New York reference, and then yada, 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 there's a lot of controversy. The Supreme Court decided in favor of New Jersey. So as of 1997, it's like 25 years ago now, New Jersey has been able to claim all of the sales tax revenue from tourists from Ellis Island and the Statue of Liberty. So, whatever other economic benefits, financial benefits there are from having Ellis Island be part of its state, I think it's relatively minor, even if it's in the millions. I guess, that's interesting. And so it's one of the only times where the Supreme Court gets to be the court of first review. It's between 2 states. So that's kind of an exception to the rule. That's what original jurisdiction is. States suing each other. Anyway. So it took decades. There was a special commission. So it's a big exception, New York and New Jersey. Okay, so appellate jurisdiction up until 1920, the Supreme Court had to hear all the cases that were appealed to it. And it took a former president, who was the Chief Justice, William Howard Taft, to say, why don't we just hear cases we want to hear? We're the ultimate authority. All the cases we can just refer all the cases except the ones we want to hear back to the lower courts. And so they've been doing that. So they only hear about 1% of cases. And so that percentage is really declining every year because they tend to hear the same absolute number of cases, somewhere between 65 and 100. And the rest are referred back to the rest, the 10,000 or so that are appealed to the Supreme Court, they're referred back to the lower courts. And that decision ends up being a binding one rather than the Supreme Court's new opinion, which doesn't exist. So that's why I say 1% here. So there's 1% of cases really and declining what the Supreme Court actually hears every year. So when you say, I'm going to appeal all the way to the Supreme Court, great, they don't have to hear it. In addition, there are two kinds of opinions, at least two kinds of opinions, but two that we're going to talk about today. One is the court opinion, also called the opinion of the court, or the majority opinion. So there's 9 justices, and at least 5 of them have to agree. On a decision. They can write an opinion of the court in a legal case that is legally binding, and the interpretation of the laws in the Constitution in a certain way are also legally binding. For example, that can declare laws that were, in 1973, laws that regulated abortion across the United States and all the states, including Texas, which is what the case was about in Roe versus Wade, declared them all null and void and unconstitutional as a violation of the right to privacy. We'll talk more about that case later in the Civil Liberties chapter. And also in Brown versus Board of Education of Topeka, Kansas. And segregation, at least the government-enforced segregation, racial segregation, was unconstitutional as a violation of the 14th Amendment specifically. That was a unanimous decision of the court. And so all of this, the way the court is structured, there's a majority opinion, and the majority opinion is binding. The dissenting opinion is the other one, dissent, also called the dissent. So let's say the other 4 justices all agree that they should have been the majority. They should have been able to persuade one more person. They should have, to come to their side. And what they're going to try to do is persuade whoever's reading the opinion that they should have been the majority, and the majority decided incorrectly at this point. So they're going to write a dissenting or minority opinion. They say, well, I disagree with this opinion, and here's why. I think I should have been the majority. More people should have voted with me. They're making a legal case, saying the majority is wrong and I'm right. Sometimes a dissent can be picked up in several years when the court has been kind of reconstituted, when there's been a few retirements or deaths and new justices have been appointed. And the court looks different now. The court in the future might say, well, clearly a dissent in this opinion last time was right, and we should adhere to that instead of to the majority opinion. So, to paraphrase one quote in your textbook, it's something like the court's opinion. The court opinion writes opinions for today, and the dissenting opinion writes opinions for tomorrow. One more thing about the Supreme Court, which is amicus briefs. Wherever there's a case in front of the Supreme Court, only the two parties agree to, and by the parties I mean the plaintiff and the defendant, person who's suing and the person who's being sued. Someone agrees who sues the defendant, and those two are the only two who are actually arguing in front of the Supreme Court, and they put together a legal brief. But oftentimes organizations who are in favor of their side winning, and the precedent being set in their favor, will submit what's called an amicus brief, or it's Latin for a friend of the court brief. So it means a friend of the court, we think the court should do this, and decide with this one respondent in the case, one plaintiff or defendant in the case. So if you belong to really any mass membership organization, chances are they have filed an amicus brief of some kind or other several times over the last few years. But the one amicus brief they look for is not from an organization, it's from an office, from the Solicitor General of the U.S. So this is a person who ranks second in the Justice Department to the Attorney General. They're a presidential appointee. They have an office physically within the Supreme Court building. They're a lawyer also. They're an attorney, I should say. They're the president's lawyer, essentially, when the Solicitor General argues in front of the court or issues an amicus brief on one side or the other. The Solicitor General's opinion, according to research, is the opinion we know of the opinion of the president and the administration, but it's agreed with more than 70% of the time. So they're often called the 10th justice. They're not appointed for life. They work in the president's administration. So most of the time the Supreme Court agrees with, or often at least, will agree with whatever the president's lawyer recommends. So amicus briefs don't carry any legal weight themselves. They're just sort of signs of what influences the Supreme Court does allow in its midst. In addition to structure, the way the court works, one of the things I've mentioned is legal precedents. Another reason the Supreme Court is important is they set legal precedents. The ultimate understanding of what a judge is, where a judge comes from, is where a judgment comes from, is from English common law. Common law is understood as kind of unwritten law. It's kind of how things have been done in the past. So, for example, in Massachusetts and New York, they have different kinds of criminal law. At least initially, Massachusetts had a law that was based on English common law, and New York had something called the Civil Code, a written criminal law. So Massachusetts, if you rob a bank and you go to prison, you have a trial, you go to prison, it's because you broke the law that other people have broken in the past, and there's a reasonably similar, precedent that's been set. Like, people who have robbed banks in the past have also gone to prison. And they've gone to prison in this way because of these reasons. But in New York, if you go to prison, you have a trial, and that's where you go, because there is a law that specifies people who rob banks aren't allowed to do that, and they should go to prison. So it's, working on precedent or written law. So, okay. So there is also a Latin term that, So that's why the Supreme Court has power in the legal system, is because it's the court of last resort, and so no court ranks higher than it. So whenever a precedent is set by the Supreme Court, like in Roe v. Wade or in Brown v. Board of Education, all lower courts then have to abide by that decision, because they assert that if they were to decide what the court's right opinion was, their opinion would be overturned at a higher level, getting appealed to somewhere along the line on the way to the Supreme Court. So it doesn't look good when you're a judge and your opinion is overturned by a higher court's appeal. So there is one more precedent. So stare decisis, which is really not decisis, how people say it. It's really not the proper Latin term. Neither is decisis. Means to let the decision stand. So if a law has been decided by the Supreme Court, they generally try to let the decision stand until there's a reason to revisit that law or decision. And if there's certain circumstances which change, that decision is supposed to be able to recognize that it should be revisited or not. Here, Okay, so let me pick up somewhere new. So probably there's a high probability that in the next several years that Roe versus Wade decision could be revisited by the Supreme Court, and actually the core holding of it overturned. That a right to privacy certainly is not acknowledged in the same way by the majority of justices who sit in the Supreme Court today as have sat in the Supreme Court in the past 40 or so years, almost 50 years since Roe versus Wade. And also school segregation, Brown versus Board, maybe not, but other decisions that upheld that segregation ruling, anti-segregation ruling, I should say, may be revisited. Miranda rights, you have the right to remain silent. That came from the Warren Court, the same court that did the Brown versus Board decision in the 50s and 60s. All of that could really be overturned at this point because you have a much more conservative court than I would say you ever have. But I also want to talk about the overarching justice system very briefly. So today, a huge amount of criminal justice is practiced by local prosecutors in the form of plea bargaining. So over 90% of the people who are sent to prison never see a trial. Their justice is meted out by a prosecutor. So if you've ever seen a movie or a TV show, you know that if you plead guilty, you might get a lesser sentence than a lesser crime on your record, maybe. Sometimes maybe less or no prison time. Sometimes the difference between a felony and a misdemeanor. Oftentimes, plea bargaining is not something that was envisioned, certainly in the initial borrowing from English common law, but in the American legal system that was set up, it's certainly been adapted. So it remains to be seen whether plea bargaining is something that is going to continue, but it certainly seems very well firmly entrenched in American law. I don't see any way right now it could be altered, but it's something that's being increasingly targeted and investigated by defendant advocacy groups and criminal justice reform movements. Certainly with the advent of the new Jim Crow phenomenon that Michelle Alexander documented in her book on mass incarceration, it's caused by numerous factors, but there is a call to improve or at least somehow reduce the number of people who are sent to prison and come up with alternatives to, I would think, things like plea bargaining are definitely going to be part of this conversation going forward as far as the federal court system is concerned. But let me say the Supreme Court has in some ways marginalized itself only to hear 1% of cases. So it's reduced their workload, but it's increased the workload of the courts directly below it. So where there are 12 U.S. courts of appeal, and I'm not sure how many justices sit on those courts of appeal, but I want to say somewhere a little under 100 judges on the courts of appeal. And the 94 U.S. district courts that have 677 federal judges sitting on them. And usually that's where lawsuits are heard, federal lawsuits are heard first, is in those U.S. district courts. And the federal court system, they're called inferior courts constitutionally. So they do the majority of law writing these days. I would say in the U.S., one interpretation, as long as they're not contradicting the Supreme Court, at least explicitly, which still has the ultimate authority on reversing those courts, they get to interpret a lot more law than the Supreme Court does. And there are numerous kinds of crimes or lawsuits that occur on a lower level that can then be appealed to the appeals courts. But the majority of law at the federal level is not written by the Supreme Court. It's written by certainly U.S. district courts and to a lesser extent the U.S. courts of appeal. But they can refer them back to the Supreme Court's power. Sorry, let me say that one more time. The Supreme Court's power is itself constantly in flux and subject to debate and influence. But it's certainly evolving in the direction of a more conservative understanding of the role of the federal government. Conservative and I think, dare I say, traditional way of seeing the way that the federal government has operated. So that is it for the Supreme Court and Judiciary and Legal lecture for right now. I hope you learned something from it, and if nothing else, I hope that it's generated some questions in your mind about what's important about any of this. And if there are questions of clarity, please don't hesitate to contact me via email or during class. Thanks very much.